In this voice thread, I'm going to introduce an area of free speech that we don't think about very much, and that is commercial speech. So I want to raise a couple of questions at the outset here. Number one, should commercial speech get any constitutional protection at all, right? Is this really what the First Amendment was intended to protect? Second, sort of like the other side of, or the other way to look at this is, well, why does the exchange of money change anything? Why should the fact that there's some sort of transaction taking place in any way reduce the free speech protections that expression receives? All right, so at the end of this voice thread, I'm also going to introduce freedom of association. So we're going to see, particularly, we're going to talk about one case, especially on the discussion board, but we're going to talk about one case where all of these things kind of come together, right? And so that's Masterpiece Cake Shop. So I'm going to make a discussion post about it, but I'll talk a little bit about it on this voice thread as well, because in Masterpiece Cake Shop, we see this kind of like nexus not only of the freedom of religion, but also freedom of speech, freedom of association, and then how this all gets reframed when there's a commercial element included. Your textbook gives a pretty good overview of how commercial speech evolved over the years. Right, so to begin with, the court didn't even consider commercial speech to be free speech at all, right? So we have this case, Valentine versus Christensen from 1942. And in that case, the court found that commercial speech is completely outside of First Amendment protections. Of course, this wasn't, always, or I mean, this didn't remain the case. So over the years, different cases arose dealing with sometimes controversial issues, sometimes questions about the role of the state in controlling what information could be put out there in commercial communications. And gradually, we see two concerns emerge. The first is the sort of obvious one, right, which is the right of the speaker to express themselves, whether that's, in a commercial context or not. But secondly, and perhaps more important to the court, we see emerging also a right for the people, right, so the audience, to have access to this information, right? So in this case, we see the freedom of speech concerns framed not only in terms of the speaker's rights, but also of the audience's rights. And so that right becomes particularly important in cases like Bigelow versus Virginia, right, which dealt with the advertisement of abortion services, and similarly with the Virginia State Board of Pharmacy. So we see in these cases from the 1970s, the right to receive information becoming increasingly important, right? And so that said, commercial speech still doesn't receive as high a level of protection as other forms of speech. But we see, if you look at Virginia State Board of Pharmacy, it from 1976, we see intermediate scrutiny being applied, right? So that's not obviously the highest level of protection, but also it could be less, right? So beneath this would be simple rational basis review, which provides very little protection. So the court eventually produced a test for deciding whether or not commercial speech could be restricted by the government. And that test is outlined in a case called Central Hudson Gas and Electric versus Public Service Commission from 1980. So we'll turn now to the Central Hudson test just very briefly. So this is the test for whether or not regulations affecting commercial speech violate the First Amendment. And those regulations do not violate the First Amendment if, number one, the regulated speech concerns an illegal activity, right? So if someone is advertising for a service or a good that is not legal where it's being advertised, then it's possible that the regulations will not violate the speaker's First Amendment rights in that case, or the audience's. So cases we might see in the present day, well, there are some states in which cannabis is legal, and there are some states in which it is not legal, right? So there's the potential that if you were advertising for a dispensary in, say, Colorado, but the venue you're advertising in was in, say, South Carolina, right, which has some of the strictest cannabis laws in the country, it is possible in that case that the government might be able to regulate that speech. Now, when I say it's possible, that's exactly what I mean. It isn't necessarily automatic. that advertisement is not going to be protected. But the courts will show greater deference to states who want to restrict that speech if the advertisement is for a service or good that is not legal. All right. So the second part of the test is if the speech is misleading, right? So this should not be surprising because, as you know, fraud is not covered by the First Amendment, right? So fraud is when someone expresses something that is A, not true, and B, for the purposes of receiving money, right? So if there is commercial expression that is misleading, that is edging towards fraud. So it is not so surprising that the court might not want to extend full First Amendment protections to speech of that kind. All right, and then third, if the government's interest in restricting the speech is quote unquote substantial, right? And the regulation in question directly advances the government's interest. Okay, this is simply telling you the level of scrutiny. So when we see the term substantial, the first thing that should pop into your mind is, yes, I have seen this before. I've seen it in the freedom of speech cases, and later on, you're going to see this language reemerge in the civil rights cases, right? So you'll see this with like public forums, for instance, the intermediate level of scrutiny. So the government's interest is quote unquote substantial, and the regulation in question directly advances that government's interest. Okay, we're applying intermediate scrutiny. And then finally, the regulation is narrowly tailored to serve the government's interest. That sounds a little bit confusing because narrowly tailored often indicates strict scrutiny. It doesn't always. The central Hudson test is actually fairly common sense, right? Like perhaps, more so than many Supreme Court tests. So it's also pretty flexible. Regulations affecting commercial speech don't have to hit all of these points in order to not be given First Amendment protection. But the court will do, as usual, some kind of balancing test between the right of the speaker to advertise their services, and also the rights of the audience to have access to that information versus the state's interest in regulating that expression. So these are sort of guidelines. This test is maybe a bit less rigid than many of them, but these are the sorts of things that the court will apply. Since the central Hudson test was put in place, the court hasn't really changed it in any major way, but the court has since made some adjustments to it. So I'm just going to talk very briefly about this case, Posadas de Puerto Rico Associates versus Tourism Company of Puerto Rico. So this is a case from 1986. This case picks up, it sort of like addresses a thread that ran through a lot of the early commercial expression cases, and this issue wasn't really settled until the 1990s. So if you look back at some of the early commercial expression cases, there is this kind of like implicit idea that the state is more free to regulate commercial expression when that commercial expression deals with quote unquote vice, right? So we've seen the idea of vice come up before, right? Just sort of like incidentally in some of the religion and speech cases. So vice is sort of similar to like, it's kind of in between sin and bad habits. When people refer to vices, they usually refer to things like drinking, using drugs, smoking, gambling, right? So things that adults are free to do, but that maybe are not good for them. So it's not just a public health issue though, right? So vice always has this moralized cast to it as well. And so as you saw with many of the advertising cases, the court tends to have a little bit more of a lenient attitude towards states that want to regulate the advertisement of services or goods that are related to vice. And so this case begins to sort of like see a change in direction when it comes to regulating advertisements about vice. However, the court did uphold this local prohibition on the advertising of casinos. So they give a rationale for it, which is like doubling down on this intermediate scrutiny piece that we saw in Central Hudson. The rationale being that there is a substantial but narrowly drawn state interest in preventing gambling, right? So the court isn't kind of giving the state carte blanche to prohibit any kind of like immoral activity that they want to. That's where this narrowly drawn part comes from here. And they do require that the state demonstrate some kind of substantial interest in preventing this. And in this case, the argument was that, gambling is a potential threat to the health, safety, and welfare of the people. So in this case, they did uphold this regulation on commercial advertising that dealt with vice. But as we'll see in the next slide, they have since backed away from that idea that vice is less deserving of protection than expression about other topics. In 1996, the court revisited this question about advertising and vice. And so this was done in a case called 44 Liquor Mart. So here the court moves away from the idea that commercial speech that promotes quote unquote vice is somehow less deserving of protection than other forms of commercial expression. And so they decide now to treat essentially all commercial expression as just being commercial expression, right? Not that some of it is more sort of like worthy of First Amendment protection than other kinds. And so the principle that they outline here in justifying that movement is that they say that the power to ban the sale or distribution of an item does not imply the power to restrict its advertisement, right? So they say that because states have the power to restrict the sale or possession of, liquor, cigarettes, drugs, etc., that doesn't necessarily mean that the state also has the power to restrict advertisements about those things. So they distinguish the sale and possession of the thing from expression related to the thing. So this might seem counterintuitive, but we'll see a similar idea emerge in some of the later restrictions on free speech cases. So for instance, cases dealing with the depiction of cruelty to animals, right? So in most jurisdictions, there's some kind of law on the books that punishes cruelty to animals. But the court, as you will see in the Stevens case, distinguishes prohibitable conduct, right, which is cruelty to animals, from depictions of that prohibitable conduct, right? So they'll say that any media depicting this still falls under the rubric of expression. And so it's the same idea essentially that we see in 44 Liquor Mart. Sure, it falls within the police powers of the states to regulate the distribution of certain potentially harmful items. That doesn't necessarily mean that the state has the power to restrict, all expression or even commercial expression regarding those same items. All right, so that's all I'm going to say for now on commercial expression. But we're going to return to this in just a moment as a kind of broad topic when we look at Masterpiece Cake Shop. We're going to turn now to freedom of association. This might seem like sort of a strange pivot from commercial speech, but this is all very sort of like closely connected. One of the reasons for this being that associations often have at their core some principle that is closely related to either expression itself or to the kinds of like deeply held principles and values that people base or use as the basis for wanting their freedom of expression in the first place. So often it's really difficult actually to separate just the pure freedom of association from expression. And we'll see this in these cases, right? You'll also see some nexus points here with the freedom of religion, right? So when you think about why people form associations, it's usually for some kind of purpose, right? So think about the associations that you yourself belong to. Maybe you hold office in some campus club. Maybe you belong to a church. Alternately, like you might belong to a homeowners association. All of these are examples of groups of people that you have voluntarily joined, generally for some purpose. So the hallmarks of associations, both as the court thinks about them and as we think of them more broadly in politics, is that they are non-governmental institutions, but that they are nonetheless groups, right? So they are groups of people that have some kind of like internal governance, right? So generally associations have some kind of rules, right? So they might be formally written, they might be unwritten, but they're there, and generally the members of the association know what they are, and they know what's going to happen if they break those rules. Um, so one of the keys to founding and preserving an association is having control over internal governance, right? So whatever the principle is that your association is organized around is probably going to structure the kinds of rules that you have. Another key to making an association what it is control over membership, right? So, for instance, if we look at religious associations or churches, we would think that it is absurd to compel, say, the local chapter of the Satanic Temple to include, Catholic clergy, right? So, and vice versa, right? Like we wouldn't compel one church to also admit members of a different religion. The reasoning for this being that if we force associations like that to open up their membership to anybody, right, or to give up their option of selecting their membership, then ultimately with those changes in membership, the nature of the association will eventually change, right? And so this is the reason for giving or for allowing associations to have control both over their internal governance and over their membership. I could say a lot more about this, and whole books have been written about it. But as you can imagine, these principles of basically self-governance and membership control for associations can pretty often lead to conflicts with the state's interest in reducing discrimination, right? And also with, other citizens' interests in not being discriminated against. So we're going to see a couple of tough cases here. So specifically Boy Scouts of America versus Dale. Now, this case has, since become kind of moot because the issue at question here is whether or not, the Boy Scouts of America can be compelled to include members among their staff who are gay or lesbian, right? And so in 2000, 20 years ago, the Boy Scouts of America were willing to go all the way to the Supreme Court about this. Subsequently, the Boy Scouts changed their own internal governance and made the rule change themselves that allowed for gays, lesbians, and then LGBTQ people more broadly to hold leadership positions. So this is, again, like the case is kind of moot, but the principles are still there, right? The case has not been overturned. So we're going to look at some of these conflicts, right, between expressive association, what the court will term intimate association, right? So that's something like a family, your friendships, a marriage. So these are relationships that are based on very close emotional ties, right, and that are highly selective. Versus, expressive associations, which are organized around some principle, right, or some mission. And then we'll see this third category proposed by Sandra Day O'Connor in her concurrence in Roberts versus United States Jaycees, which is the quote unquote commercial association, right? Now, the court just doesn't pick that up. Her third category is just kind of left to sort of wither there in Roberts versus United States Jaycees. But I'm going to raise the question, is this actually maybe a useful category? Should we preserve this? Does it help us make sense of other questions that arise, right? So for instance, we'll see some cases like Burwell versus Hobby Lobby. We'll see, we're also going to look at Masterpiece Cake Shop. I'm just going to do a brief voice thread about that. I'm sorry, a brief commentary on that at the end of this voice thread. But these are cases in which we see the same kinds of principles lying at the heart of freedom of association being invoked to protect internal governance and membership decisions and basically endorsing values in the context not of a club or a church, but of a business corporation. And so the court just doesn't really have a lot of good ways to deal with this. As your book mentions, they kind of punt the question in Masterpiece Cake Shop, and instead of addressing these sort of more basic questions about association and discrimination, they instead treat it as a free exercise case. So we're going to raise a lot of questions in our discussion of associations that don't have easy answers. But for those of you who are still looking for a case to present on, there are some really interesting cases on association. So I keep mentioning Masterpiece Cake Shop, but that case is sort of a treasure trove of confused issues and confused arguments. And because that case made basically no one happy, there's a lot of critique still to be done on it. Similarly, I think Roberts v. United States JCs has a lot of potential, and it remains obviously an influential case. So if you're looking for something to present on, consider an association case. In the next VoiceThread, we will delve a little bit more deeply into some specifics of association cases, and specifically the cases that I just mentioned, right? So Roberts versus JCs, Boy Scouts versus Dale, Christian Legal Society versus Martinez. But for now, I want to set up some of the big questions, and I want to do that in the context of a case that isn't usually treated necessarily as an association case, but that raises a lot of the same questions. So I want to look at this in terms of the commercial association. So just to be clear, the court does not currently recognize commercial associations as being a type of association. Currently, when they look at private associations, they see essentially two types, right? So there's an intimate association, right? So that's family, friendship, right? So maybe your trivia team might fall under this, right? So these are small groups of people that we associate with for personal reasons. They also recognize what they call an expressive association, right? And so these are associations that are organized around some set of principles that are kind of fundamental to like your First Amendment freedoms, right? So that might be groups that are religious in nature, groups with a political message. And so these expressive groups are given also a little bit more First Amendment protection than other kinds. And then the third kind of association they recognize is just kind of everything else, right? And so just as a preview of JCs, they're going to find that the JCs fall into that category, right? So they're they're an association, but they're not an intimate one. They're not necessarily an expressive one. And so while, yes, people have the freedom to associate, there is more space to infringe on certain kinds of associations than others. Now, as I mentioned, in JCs, Sandra Day O'Connor gives this concurrence in which she argues that perhaps something like the JCs should be treated as a quote-unquote commercial association, right? So their purpose is essentially to, promote commercial activity or, seek profits. Obviously, the court doesn't pick this category up and start using it. But as I said before, maybe this is a useful category that they should consider. So some questions I want to raise about differentiating types of association from commercial ventures are these, right? So number one, why should the introduction of monetary exchange affect how much protection is afforded to expression? So this is one of the questions underlying all the commercial expression cases in the first place. And, this might seem like kind of low stakes when we're just talking about what can be advertised and what can't. But when we start to look at these corporations that are also like so closely held is the term that the law uses, but these might be like family businesses, right? And so on the one hand, yeah, they're commercial enterprises, but on the other hand, they're also very personal associations. And the people who run them might be very invested in the message and the values of that corporation. So some commercial speech issues actually end up implicating some pretty fundamental freedoms. So we see this, as I said, come up in like Hobby Lobby, also in Masterpiece Cake Shop. So another question I want to raise is, are there potential principal agent problems in treating commercial activities being expressive, right? So one of the things that we see in commercial activity is the employer-employee relationship. Employees are not necessarily expressing themselves when you go into Target and they say, hello, welcome to Target. That isn't necessarily, something that is close to the associate's heart. They're being paid to undertake certain kinds of expression. That's not necessarily their own. So when I say, is there a principal agent problem here? I mean, are we assigning the action to the wrong actor? Whose expression is actually at stake? Is it the person, who is doing the speaking on behalf of the company, the employee? Or is it the corporation owner, right? This is where things get a little bit murkier. Is it the board of the corporation? So it's difficult to say actually whose expression specifically is at stake. All right, so these are just some sort of like meta questions to consider as we move into more discussions about associations in the next voice thread, but also in the brief discussion of Masterpiece Cake Shop that I'm just about to make. I'm going to just now give you a brief overview of Masterpiece Cake Shop because I think it's a good kind of like transition case here. If you haven't yet chosen a case for presentation one, I would strongly recommend doing Masterpiece Cake Shop. So the entire text of the decision is available on justia.com. This is a great one to kind of like top off the First Amendment with because it kind of involves everything, right? This is it's a really weird case. As your textbook says, the court kind of sidesteps all of the major issues in Masterpiece Cake Shop. And it's one of these decisions that like really doesn't make anyone happy, but that a lot of people have very strong feelings about and opinions about. So you've probably heard of this case. It was all over the news in 2018 when it was decided. This is the case about the baker in Colorado who did not want to bake a wedding cake for a gay couple. So the argument from the baker, whose name is Phillips, was that this was a violation of his religious beliefs. He didn't support gay marriage. Therefore, he thought that this was a violation of his religious beliefs to be penalized for refusing to bake this cake, right? So the issue that came up was that he was found to be in violation of a Colorado civil rights law that required equal treatment for people on a number of bases, but one of them being sexual orientation. So the way this case ultimately is decided is, again, like I said, it's kind of weak. It's decided on basically procedural grounds, right? So the court goes back and looks at how the Civil Rights Commission treated Phillips. They look at the language that's like recorded in the discussion, and they say that the Civil Rights Commission showed quote unquote animus, right, or hostility towards Phillips' religion. So there are all of these really interesting questions of potential compelled association here, right? So we'll talk about that in more detail in the next voice thread with JCs or Roberts versus JCs and Boy Scouts versus Dale. But just the kind of short version of this is that the court has recognized at least a limited right to be free from associating with people or ideas that you don't want to be associated with. So, I mean, arguably, like Phillips could have made this argument that this is compelled association, right? I'm being asked to endorse something that I do not endorse through this commercial transaction. That is not how the court treated this. It would have been a much more interesting opinion if they had. There could have been this question of commercial expression also, right? So as I said, there are like principal agent problems that arise when someone is paying for a specific service. And in this case, wedding cakes are a thing you commission. The sentiment that is expressed on the cake isn't the baker's sentiment, right? If you went into a baker and said, like, I would like to pay you to make me a cake that says, happy birthday, mom, and you give them your money, you come back the next day, you pick up your cake, and the cake says, live free or die. You'd probably be pretty angry because that is not the message that you paid them to put on the cake. So whose expression is at stake here, right? In that case, you want your cake to say happy birthday, mom, not live free or die. So there's this question of commercial expression. There's a question of compelled association. And all of these are left dangling. So again, if you haven't chosen a presentation case yet, this is a really interesting one because there are just so many questions raised and not answered. All right, so I've mentioned the basic facts of this case. You can access, as I've mentioned before, you can access the whole opinion on justia.com. It's a whole sort of like twisty, windy trail to the Supreme Court. But ultimately, the decision is made on neutrality grounds, right? So if you read the facts of this case, your first thought is not going to be like, oh, yes, this is a classic free exercise case, because it's not. But that's the way it got decided. So the court looked at how the Colorado Civil Rights Commission applied the law, right, to Phillips specifically. And they say that they were not neutral with regard to religion. And in fact, they look at the records of the conversation involving the decision, and they say, look, the people in the Colorado Civil Rights Commission they expressed hostility towards religion, and specifically towards Phillips's religious beliefs. So that is the way they end up deciding this case. So the holding shows, and I quote, like, selective hostility to a baker's sincerely held beliefs, right? So this ends up being decided as a neutrality case. And they say that by not showing neutrality, the Colorado Civil Rights Commission violated Phillips' right to exercise his religion. But again, I'd like to raise some of these like unanswered questions. I mean, I guess I'll open a discussion post on this too, but like, how do you think this case should have been decided? I think it's clear why the court decided it this way, but ultimately, this didn't necessarily have any effect of being action guiding for lower courts, because like, what happens now if another case comes up with a photographer who maybe doesn't want to work for a gay wedding? You know, what happens, you know, with the next cake case that comes up? This is not generalizable, because this was decided specifically on this one little fact about how the Colorado Civil Rights Commission, you know, treated Phillips specifically. We can't really get any principles out of this. So I guess my question is, treating this as either a commercial expression case or as a compelled association case, how do you think Masterpiece Cake Shop should have been decided? So keep these issues about Masterpiece Cake Shop sort of in the back of your head as we move into the next voice thread, in which we're going to look specifically at the compelled association cases. Here's the prompt from the discussion board. So, how should this have been decided? So here are some possibilities. So 1, should this have been decided as a freedom of expression case? Phillips claims that his cake is artistic expression, right? So he says, right, the cake is itself his art, it's his expression. So again, this raises that kind of principal agent question here, because again, he was commissioned by someone else to put a particular sentiment on the cake. Second, you know, how do you think the court did in weighing discrimination claims here against the free exercise claims? Another really interesting question that the court didn't answer. Second, you know, is this compelled association, right? So we've talked a little bit about Woolley versus Maynard, right? So this is the Jehovah's Witness license plate case, or license plate case. So this is where, you know, the state of New Hampshire, all of their license plates say "Live Free or Die." But, you know, this Jehovah's Witness found that offensive. He thought that it was expressing a priority of loyalties that violated his religious beliefs, because his first loyalty should be, you know, to God, not to the state. So this is kind of similar actually to the objection in the Pledge of Allegiance cases, and the flag salute cases. So he covers up, you know, "Live Free or Die" in his license plate, and he is then in trouble with the state, basically, for defacing his license plate. Well, isn't this similarly like a compelled association case? Could we say that this is, or a compelled speech case? You know, is Phillips being pressured by the state to either associate himself with ideas that he doesn't endorse, or, you know, associate with people that he disapproves of, or to express a sentiment that he disagrees with? Okay, and then finally, I come back to the first question that I asked at the beginning of this commercial speech voice thread, which is, Phillips is being paid for a service. So why is, you know, should being paid necessarily diminish his claim to free expression? Or, you know, is that irrelevant? The man is an artist. His cakes are his art, you know, regardless of whether he's being paid for them. All right, so that concludes this voice thread. The next one is going to go specifically into the association cases.